Advocate Vasadikar, President of today's function and of this society, Dr. Rao, Principal of the Law College, Dr. Mrs. Vajpayee, Principal of Mahila College, all the Honorable Judges of the High Court, present and former, some of the judicial officers who are present here, the honorable and learned members of the bar, senior advocates as well as junior advocates, the faculty members of both these colleges, the students of these colleges, ladies and gentlemen. At the outset, I must express my gratitude that I have been invited to share my views on certain topics with you. I join long list of galaxy of members who have on previous occasions had the privilege of addressing gatherings like this. I see so many persons who by their very looks don't appear to be members of the bar. So it has generated some response amongst the members of the community here at Aurangabad. And all thanks must go to the management, the organizers of this function, and especially Mr. Shrikant Adwant, the advocate of Aurangabad Bar Association. So here I am before you on a topic which is judicial review as basic feature of the Constitution. We all know we have a written Constitution which was adopted by our founding fathers. Today it was a great occasion that when the preamble was read out, so we adopted this Constitution on 26th of November 1949, which came into effect 2 months thereafter, that is on 26th of January 1950. That's the day we celebrate as our Republic Day. Everybody all over the world considers this to be a fantastic document which has been put in place, which has considered all pros and cons, has visualized everything, including the development of a nation which till then was under the colonization for almost 150 years, where poverty was the thumb rule everywhere, illiteracy was shockingly at a proportion of almost 70%. And for a polity or for a country with people of this kind of nature, number two, vast differences, beautiful diversity. To give them a written document, it took our founding fathers almost 3 years of toil and perseverance, at the end of which this document has been given to us. Like every constitution, this Constitution of India was also contemplated to be a dynamic, a living document. And no constitution can survive if there are no adequate safeguards, including provisions to amend the Constitution itself. You can't visualize in 1947 and 1950 what problems perhaps the future generations may face after 50, 60 decades. So therefore there has to be a provision for amendment of the Constitution, and naturally our Constitution also made a provision in Article 368 speaking about amendments. Mind you, our Constitution though taken as a written constitution and modeled on the experience of American Constitution, as a democracy we adopted parliamentary democracy, that's the Westminster model or the United Kingdom model. United Kingdom prides on one theory that Parliament can make and unmake anything on the earth. That is, there is no limitation on the power of amendment of the British Parliament to make or unmake any provision, any law, any enactment. Some of the critics say that Parliament can make or unmake. Parliament can turn a man into a woman and woman into a man. That's the extent to which the power of the Parliament has always been perceived, has been acknowledged. So our constitution is modeled on Westminster model, which is parliamentary democracy, but we thought of giving to ourselves a written document, which is written constitution. Naturally, we made a provision for amendment in that constitution itself. At this point in time, I must tell you some of the provisions of the Constitution which will have some relevance in the address that I intend to make hereafter. Our Constitution has various parts. Part 3 speaks of fundamental rights, which are a bunch of rights which are said to be inhering in every human being, and for the benefit, for the upliftment, for the advancement of the highest potential of every individual, these rights, which are called fundamental rights, are a cherished lot. So therefore, on one side, we have Part 3 of the Constitution, which speaks of fundamental rights. Immediately thereafter, there is Part 4 of the Constitution, which speaks of ideals before the state. That is to say, what shall the state hereafter do for the upliftment of the entire lot of people? So we call them directive principles of state policy. These are the governing principles for every state, be it central government or be it state government or any other authority in the region. So therefore, there are ideals in Part 4. Part 4 ideals are not enforceable, but these are the guiding principles which will be beacon of light for various state legislatures, executive action to be guided with. So their actions are to be guided going by the principles in Part 4. On the other hand, Part 3 rights, which are fundamental rights, are enforceable, and we have one provision which is called Sub-Article 2 of 13, which states, any law which infringes or which violates fundamental right of a citizen shall be invalid to the extent that such transgression is spoken of. So therefore, to the extent that the law violates the fundamental right, that particular clause in the statute can be struck down by the court, being violative of the Constitution. Second, which is Article 32, that's also part of Part 3, which is a fundamental right. It states that for the enforcement of the fundamental rights, every person, every citizen shall have the right to approach the Supreme Court, and it shall be the duty of the Supreme Court, in plain words, to see that the violation of such rights is definitely addressed, redressal is given to that person. For the purposes of granting redressal, the Supreme Court is empowered to issue various writs, including some of the classical writs. In the words of our founding father, Dr. Ambedkar, this Article 32 was stated to be the heart and soul of the Constitution. Now, mark it. Why does the chief architect of the Constitution say Article 32 is the heart and soul of the Constitution? Because he is conscious of the fact that though we may have given you a beautiful document, while executing, while working under that Constitution, there can be various situations where a citizen may be required to go to a court of law to seek redressal. And such a venue itself must be a fundamental right, and the duty is cast on the Supreme Court. So therefore, the avenue, the access to reach that court of law, according to Ambedkar, was the heart and soul of the Constitution. It is in this setting that we must consider the advancement of various cases and how the matter unfolded. In 1951, the First Amendment to the Constitution, what happened was that though we adopted the Constitution which came into force in 1950, everybody is aware that first parliamentary elections actually took place in the year 1952. So who was managing the affairs? Who was conducting everything? Who was responsible for the upliftment, for the good of the society? It was the very same Constituent Assembly which was actually in charge of the entire affairs of the community and the country. So the First Amendment which came into effect was the handiwork of this very assembly. And many thinkers are of the view that the First Amendment actually epitomizes what was the rationale with which the original assembly, the Constituent Assembly or the founding fathers had thought of giving this document to us. So according to various thinkers, First Amendment is actually the very essence of the Constitution, which for reasons perhaps got left out or was not specified by the founding fathers, and therefore in order to make something which was completely implicit, they have now chosen to make it explicit. So the First Amendment brought in what is called 31A and B, which in plain words are some of the land reforms which were thought of by the Indian state to bring about changes in the society, to have an egalitarian society, and to see that the tiller of the land, to see that the person who actually does the agricultural operations is given the ownership of lands, to see that the disparity in the society is completely nullified. So therefore, various agrarian reforms, various legislations which were on the anvil or which were round the horizon. Kameshwar Prasad Singh was the first case which struck down certain measures. And that brought in, among others, Champakam Dorai Rajan was another case where certain directions were issued. In order to nullify the effects of these judgments, First Amendment was brought in. And it brought in a concept which is under 31A and 31B, that certain legislation should be beyond the pale of scrutiny by the courts of law. Why? Because we had thought of, judicial review as one of the features of the Constitution. But at the same time, there are certain developmental works, there are certain legislations which are rooted firmly in bringing egalitarian society. So therefore, your thoughts are ideal, but at some stage, it transgresses some of the individual rights of citizen, and there would be a tussle. So in order to get over these situations, the First Amendment brought in certain amendments to the Constitution. The challenge in Sankari Prasad went on this background. That was a decision of 1951 by Justice Patanjali Sastry, Chief Justice. 13.2 says that any law which is violative of fundamental right of a citizen, to that extent the law shall be declared invalid or the law shall be void. So first and foremost submission, whether the expression law used in 13.2 would include even the constitutional amendment. In Sankari Prasad, bench of 5 judges headed by Justice Patanjali Sastry rejected the submission. They said that when you speak of law in 13.2, it cannot be amendment which has been brought about in exercise of constituent power of the parliament. So therefore the constituent power of the parliament would be beyond the scrutiny under 13.2. Now mind you, under 368 there are rather the amendment provisions in the constitutions are of 3 nature. There is one part which is done by pure majority of the House. There are certain provisions like Article 4. For instance, we have reorganization of states. Bihar gets bifurcated into Bihar and Jharkhand. Madhya Pradesh gets bifurcated into Madhya Pradesh and Chhattisgarh. UP gets bifurcated into UP and Uttarakhand. These kind of measures, as a result of which the area of the state either gets diminished or gets increased. We had reorganization way back in 50s where Maharashtra was carved out from state of Bombay and certain areas from other states, Madhya Bharat, etc. This is called, under Article 4 itself, it says that such kind of measures shall not amount to amendment within the meaning of 368. So therefore one part is that you make certain amendments which do not even require any special majority, but ordinary majority of the House is good enough. Then there are amendments which are spoken of in 368, which say majority of the House when 2/3 of the House members are sitting present and voting. That is, in order to carry that amendment, first and foremost, 2/3 of the members must be present and voting, and then you must secure what is called a majority. There are certain amendments which are going to the root of everything, that is the federal polity of this country, the powers of the state legislature and the union legislature in terms of list 7, or rather schedule 7, list 1, 2, 3. Certain provisions which require not just the majority, as I told you, which is majority with 2/3 members present and voting, but also 50% of the states must ratify such amendment. So there are 3 modalities which are available under the Constitution for effecting amendment. All this is spoken of by Patanjali Sastry in that judgment. And he rejected the theory that law would include amendment to the Constitution. So we traveled along this idea that constitutional amendments stand on a better footing as against the ordinary statutes. Then comes the decision in Sajjan Singh. In Sajjan Singh, it was a bench presided over by Justice Gajendra Gadkar, the then Chief Justice, again a bench of 5 judges. Justice Gajendra Gadkar, speaking for the majority, adopts whatever Justice Patanjali Shastri had said in Shankari Prasad and says, he reiterates that principle, giving certain additional reasons in support of the theory that the law must not include amendments to the Constitution. But two judges, Justice Hidayatullah, specifically make a mention that I don't think this idea in Shankari Prasad is a great principle of acceptance. I would rather have the court to go deeper into this question. He also gives certain examples, but the beautiful assessment came through the judgment of Justice Mudholkar, another judge who was in minority. And he gives an example. Political democracy is founded on certain principles. Supposing if the democratic idea itself is amended by the parliament and is discarded, will you then say that such amendments would be beyond the pale of scrutiny and beyond the pale of consideration by the court? So he expressed great reservation so far as Shankari Prasad law is concerned. So according to him, there must be some area where scrutiny must be available before the court to even test a constitutional amendment. And that, to my mind, was the seed of what is called basic feature of the Constitution getting sown in our jurisprudence for the first time. All this happened in 1965. Then comes one more decision, which is I.C. Golaknath. Golaknath was a bench of 11 judges. And the decision went 6-5. K. Subara was the Chief Justice. He wrote a judgment which is the lead judgment, supported by Hidayatullah, who had earlier expressed certain reservations in Sajjan Singh. And the matter was considered by them from the perspective of Article 13(2). They said that this power of amendment, when you think in terms of what? We are not having a referendum where every citizen is consulted. This is a power which is given to the parliament. And the parliament in its wisdom, day one it may be doing some legislative work, day two it may take up constitution amendments. So according to the majority, the amendment to the Constitution was purely legislative in character. If it is legislative in character, it must stand the scrutiny of 13(2). That is to say, it must conform to Part 3, rights of an individual, Part 3, rights of a citizen. Logical consequence? If it violates somebody's fundamental right, then even a constitutional amendment can be struck down. They, of course, came out with the theory that this shall be prospective overruling. So, therefore, this shall apply prospectively. Whatever had happened earlier is gone. But the theory that 13(2) becomes your fulcrum, and on the basis of 13(2) and Part 3 rights, even a constitutional amendment can perish, was a theory which was advocated in Golaknath. 6 judges endorsing this theory, 5 judges in opposition. So the decision went 6-5. Immediately, the matter was taken on a different note, but came up before 13 judges of the Supreme Court in Keshwananda Bharati, which is considered the most important judgment in our jurisprudence. The matter came up before 13 judges, presided over by Justice Sikri, who was the Chief Justice then. Out of 13, 11 judgments. So 13 judges came out with 11 judgments. Sum and substance is, the matter went 7-6. So majority is 7, minority is 6. According to majority, I.C. Golaknath was wrongly decided. So I.C. Golaknath is not a good law. That is to say, your constitutional amendment must be in conformity with 13(2). They said, sorry, you are actually dealing with constitutional power. You are coming out with amendments in your constituent power. So therefore, please don't equate them with normal legislative instruments. But being conscious of the fact that you can't have a wholesale allowance to the state apparatus or the parliament to come out with any amendment, this majority devised what is called basic features of the Constitution. What are the basic features of the Constitution? Each one of the judgments varies. No two judgments are absolutely identical and say that these are the basic features. But over a period of time, analyzing these judgments rendered by 7 judges, what we have are certain features which have been accepted to be the basic features. So what is the limitation on Parliament's power to amend? To say in colloquial words, you gentlemen and ladies who form the Parliament, amend you may that Constitution, but please be aware of certain basic elements of our polity, of our democracy, of our society, and those rights are inviolable, inviolate, and absolute. Please don't do away with that. So when you say please don't do away, what is that core? So according to them, there is a core principle behind our democracy. There are certain sets of principles. And those sets of principles are nothing but what we now refer to them as basic features of the Constitution. To tell this gathering, supposing in case you bring in a concept, we have democracy which is founded on adult suffrage. Every person, regardless of his sex, religion, caste, creed, station in life, whether he is affluent, whether he is a completely sort of, dependent on the doles given by the state. Every person has one vote, which is votes are equal. So all citizens stand equal before the eyes of law. Supposing you have a constitutional amendment which brings in certain requirements that you must be a graduate in some of the disciplines so that you are well informed about the intricacies of democratic form of government. You must be owning some property so that you have a financial stake in the apparatus of the government. If these kind of amendments are brought in and certain sections of people are thrown out from participating in the elections, will it be consistent with our democratic ideals? If adult suffrage, if you say that this particular house which has been elected shall be the house for next 50 years or 30 years, we have certain ideals, that is to say that our our people must have the right to choose their representatives through periodic elections. Adult suffrage, rights of individual, equality of status before law, these are inviolable principles. So you may make any cosmetic changes in the Constitution, but please don't do away with certain basic features of the Constitution. And among those basic features of the Constitution, what is today's topic is one of them, which is judicial review. Now, when you say judicial review, what do you mean by that? In Marbury versus Madison, which is an American decision almost 200 years back, Chief Justice Marshall, speaking for the US Supreme Court, said that the courts are invested with the power to supervise every executive action in case it violates somebody's rights. And in exercise of that power, we may strike down such action, executive action or statutory instrument, if it violates rights of the citizen. That is what is called the classical idea of judicial review. We have adopted a society where there are three normal chambers. One is legislative wing, the other is executive wing, and the third is judicial wing of the state. The function of the legislature is to hand down laws or certain sets of laws which are made by the legislature so that the society can face the challenges in present time or in future. Executive is vested with the power to execute those policies all over the state. But if there be any friction, if there be any violation, which is the chamber which will grant you redressal? It is the chamber which is judiciary. So the third chamber, which is judiciary, is also equally important. And what is the function which the judiciary is supposed to discharge? It is to see that these two chambers, which is the legislative wing and the executive wing, are performing their obligations or duties well within the boundaries which are prescribed. Any overstepping by them, any outreach by them, will be checked by the judiciary. So therefore, along with judicial review, we have another concept, which is separation of powers. Along with these two principles, there is another principle, which is rule of law. The moment you have written constitution, you have, rather than whimsical ideas which are coming forth from an individual or set of individuals, you will have instruments of law which are so chiseled and which are so sort of, should be in conformity with the constitutional morality and principles, that you say that this is what the principle is, that we are to be governed by sets of principles which are fully embedded in what is called rule of law. The law will be governing feature so far as the human relationships across the length and breadth of the country are concerned. So the third principle is judicial review, separation of powers, rule of law. Along with it comes another principle, which is to say, very well, you will have the idea of judicial review. But who shall appoint the judges? Our constitution has a very beautiful idea where the district judiciary is appointed, selected, posted, promoted, and even disciplinary action is taken by the judicial wing itself. The executive is not given this power to have say in matters of promotion, posting, selection, everything connected with district judiciary. So our constitution makers thought of independent judiciary at the district level and made adequate provisions in the constitution. So it has always been thought that if you want adequate and full power of exercise by the courts in exercise of their power of judicial review, then the courts must also be independent. They should not be dependent on executive fiat or their dicta. So these four concepts go together. That is to say, rule of law, independence of judiciary, judicial review, and separation of powers. So when we pick up one of these, perhaps there would be shades of other three notions as well, which may get percolated when we think of that. Very well. So let's now concentrate on judicial review. By judicial review, what we mean is that our constitution has devised a mechanism in terms of which there shall be Supreme Court at the apex level for the entire country, and there shall be high courts at every provincial or state level. So there will be Bombay High Court for Maharashtra, there will be Madhya Pradesh High Court for Madhya Pradesh, Gujarat High Court for Gujarat, state-wise high courts. And at the apex level, at the highest level, is the Supreme Court. So those judges who constitute these courts, while discharging their judicial functions, can deal with any submission, including the submission that some of the statutes are invalid, some of the statutes violate the fundamental rights of the citizen, and after Keshwanand Bharati, even a constitutional amendment can be looked into by these courts to see whether basic features are violated or not. This power which is entrusted in the judicial wing of the superior judiciary is normally called power of judicial review. So mind you, even if a statute violates, judiciary can set it aside. Constitutional amendment can also be set aside. Executive actions, of course, yes. So that's the level to which we have gone. So we say judicial review is paramount and important feature of the Constitution. It is a basic feature of the Constitution. So let us see how it has worked in few cases. The first of the cases with which the Supreme Court had to deal with this, mind you, Keshwanand Bharati was decided in the year 1973. In 75, there was imposition of emergency. During the period of emergency, 42nd Amendment was brought on the statute book, which made certain amendments to the Constitution. And one of the amendments was that the forum to adjudicate the disputes pertaining to elections, according to that amendment, was completely changed. And these kind of elections would be beyond the purview of such adjudicating forum. So that amendment, that provision was under challenge before the Supreme Court in Indira Nehru Gandhi. And the lead judgment is by Chief Justice Chandrachud, Y.V. Chandrachud, the Senior Justice Chandrachud. And mind you, Justice Chandrachud was in minority in Keshwanand Bharati. He was amongst the 6 judges who did not think that there can be any challenge so far as basic features are concerned. Yet, he found that in terms of the majority decision of Keshwanand Bharati, I must also tell you one more feature. This comes in the judgment of Justice Chandrachud. That though 13 judges constituted the bench, after having seen 11 judgments, a short order, one-page order was formulated to say that what is the view of the majority, so that it will be easier for the entire country and the community to understand what is the significance, what are the features of the judgment. And that order was signed only by 9 judges. It appears that 4 other judges did not sign or refused to sign. One doesn't know the historical perspective behind that, but the signed order is by only 9 judges. And Justice Chandrachud then goes into that order signed by 9 judges and some of the leading judgments which were rendered by 7 honorable judges which formed the majority. And he comes to the conclusion that judicial review is the essential or basic feature of the Constitution, going by the majority decision of those 7 honorable judges. If judicial review is one of the features, then how can there be a constitutional amendment which says that the forum for adjudication to go into election disputes shall not be there? So therefore, according to him, this constitutional amendment is required to be struck down. So the first exercise of power where a constitutional amendment was struck down on the ground that it violates the principle of judicial review was Indira Nehru Gandhi sometime in 77, 78. So within how many? 4 years, 4 or 5 years. Then comes next decision, which is also very, very crucial. Justice Bhagwati was part of Indira Nehru Gandhi. And in the second decision, Minerva Mills, Bhagwati rendered a common judgment in Minerva Mills as well as in Vaman Rao. So it's a common judgment in 2 cases. But again, the lead judgment is by Chief Justice Chandrachud. In Minerva Mills, what happened is, again by 42nd Amendment, one provision was inserted in 368, bringing back the legacies of the old law, that a constitutional amendment is beyond the purview of challenge. This was brought in by constitutional amendment, which is 42nd Amendment. Though that legacy was actually sort of given a complete burial in Keshwanand Bharti. So this provision in the 42nd Amendment, that was also struck down in Minerva Mills. And in Minerva Mills, there was one more provision, which was that I told you the 2 compartments, which is Part 3 and Part 4. So what was original idea under the First Amendment was that if there be any law which has been brought in effect to effectuate the principles of 39B and C, one of the directive principles, that is to say that the material wealth of the community shall be shared, then such laws will not be challenged before the court of law. By 42nd Amendment, this expression, anything to effectuate principles enshrined in 39B and C, was expanded to say anything to effectuate principles of directive policy. So therefore, the moment you are trying to effectuate principles of directive state policy, they would be beyond the pale of challenge. This provision was also struck down in Minerva Mills. So we have 2 beautiful judgments, which is Indira Nehru Gandhi and Minerva Mills, which came soon after the celebrated decision in Keshwanand Bharti. Both these judgments are premised on that judicial review is one of the basic features. You can't lock a citizen and say that you shall not have any right. The citizen must have, and access to challenge every provision in the statute, including the statute or even the constitutional amendment, before a court of law. Therefore, the court of law have that highest power of judicial review. That's a very basic and foundational power. You can't do away with that power. So therefore, judicial review, anything which transgresses that idea of judicial review should perish. So these are the two principles which are emanating from these two judgments. The next set of two judgments. Again, we go back to 42nd Amendment. 42nd Amendment brought in the concept of what is called administrative tribunals in the country. They were thought of as expedited process where service jurisprudence matters can be dealt with immediately by a specialist body, a technical body, rather than clogging the High Courts and the Supreme Court. So while empowering these kind of tribunals, a provision in one of the articles said that yes, you can do that, but you can also take away the power of High Court under 226, which is the basic power of judicial review by the High Court in terms of the Constitution, and have a tribunal exercising that power. So the issue arose whether by doing such mechanism is judicial review given a go-by. Aren't we transgressing the very basic idea of judicial review? Justice Bhagwati, presiding over a bench as Chief Justice, wrote a supplementary note, but the main judgment is by Justice Ranganath Mishra. And the thrust of that judgment is that if you are creating an alternative institutional mechanism to exercise similar powers as the High Court, then there is nothing wrong. All that you are saying is High Courts will not exercise that power under 226, but we are creating alternative institutional mechanism in the form of administrative tribunals which shall now exercise those powers. So the moment you create alternative dispute resolution mechanism, you are not bottling or you are not stopping a citizen from seeking redressal before a competent mechanized court. And therefore, there is nothing wrong if such a process is adopted. So Sampath Kumar was the decision which was decided by a bench of 5 judges, Bhagwati presiding, and the challenge was negated. This judgment came sometime on, both the judgments are in December 1986. Justice Bhagwati retired in December 1986. Just before his retirement, these two judgments came. Sampath Kumar is one, perhaps 8th of December or something, and the other one is 20th of December, which is P. Samba Murthy. Again, a provision of 42nd Amendment. This time, the amendment said that just as we are having administrative tribunals, we will have tribunals in various disciplines, like say sales tax tribunal, like any other kind of tribunals. So we will devise and put in place certain tribunals, especially in state of Andhra Pradesh. And while constituting these tribunals, one of the subsections of that concerned article said that the decision of the tribunal shall be subject to approval by the executive. That judgment now is rendered by Chief Justice Bhagwati, saying that how can you in wildest dreams have this kind of power that an adjudicating authority decides something which will be then subject to approval or acceptance by the executive. So you are giving paramountcy or primacy to the executive to sit over the judgments or decisions of the adjudicating wing. Of course, this was in the context, Bhagwati says that in Sampat Kumar, I have said there can be alternative institutional mechanism. So tribunals you may constitute, but how can you make decision of a tribunal subject to the acceptance by the executive? Then he gives instances saying that I have seen even interim orders not being approved by the executive. He says this is shocking. That's the expression which he says. And he says that this kind of inverting the entire idea that judicial wing is supposed to be subordinate to executive, rather than seeing that executive acts within the sphere of its boundaries, it is now supposed to be an executive who will be overseeing the adjudicating wing's decisions. So he says that is subversive of rule of law and it cannot be consistent with principles of judicial review. So we have two judgments, and mind you, it's the same judge combination. All 5 judges are identical. In Sampat Kumar, they reject the submission. In Sambamurthy, they accept the submission and set aside the constitutional amendment. Taking this logic further, what happened is one division bench in Andhra Pradesh High Court, found this entire logic in Sampat Kumar to be unacceptable. According to that division bench, if you consider 226 to be part of your sublime doctrine of judicial review, then how can you bypass 226 and create administrative tribunals and say that the decisions of the administrative tribunal can be challenged only in the Supreme Court and not before the High Court? You're virtually throwing 226 in the backdrop or in the background. And that division bench then said that Sampat Kumar is per incuriam. Per incuriam is to say that Sampat Kumar was wrongly decided. Mind you, this is bench of the High Court saying that Supreme Court went wrong in deciding Sampat Kumar. And the matter went before the Supreme Court. It got referred to bench of 7 judges. And to the credit of Supreme Court has extensively quoted from that judgment of the division bench of the High Court in L. Chandra Kumar. And in L. Chandra Kumar, which is the bench of 7 judges, Supreme Court now says that Sampat Kumar was wrongly decided. You cannot bypass 226. You cannot bypass very essential forum or fulcrum of judicial review in the entire state apparatus. You may create administrative tribunals if you wish to, but the decisions of the administrative tribunal can now be challenged before the High Court. So you are preserving what is your 226 or judicial review remedy, and at the same time you want specialized tribunals to go into the very mechanics or very situations of challenges so far as service jurisprudence is concerned. So L. Chandra Kumar restored what is called the judicial review as the founding or the foundational principle in our entire jurisprudence. So these 3 decisions will show you how the judicial thinking has kept pace with our modern ideas, and this we have come to accept now, that 226, you can't tinker with 226, you can't tinker with 32, you can't tinker with 136 and 227. Very well, we started with 2, now these 3, 5 judgments. Then I want you to consider one judgment which is Kihoto Holohan. We have a very peculiar problem, and that is to say that our political representatives at times cross over and join another political party. So in order to curb this crossover or the concept of crossing over, Schedule 10 was added to the Constitution by way of a constitutional amendment. It brought in what is called anti-defection law. And anti-defection law then now says that if a person casts a vote against the directions issued by the political party to which he belongs, then such person may incur disqualification. Of course, subject to what is split and what is merger, etc. That's not the idea for this discussion. But the principle is that if a person crosses over and defects from his original party to another party, then he can incur disqualification. Now, who decides whether this person has incurred disqualification or not? The power is given by the 10th schedule to the speaker or to the chairperson of the house to decide all these issues, whether such and such member has incurred disqualification and what shall be the order to be passed in those matters. The provision of 10th schedule to the Constitution also says that the decision of the speaker shall be final. What happens to your 226? What happens to 32? This is again a constitutional amendment. So tested on the anvil of principles of Keshwanand Bharati, judicial review is paramount. Where is the avenue for judicial review? So in Quixote Holohan and all those cases, Supreme Court said, you may say that speaker's decision, but it can still be challenged under 226. And that is where the Supreme Court still restored the faith of the community in the judicial organ of the state. That is to say that all these decisions can be tested before the judicature. So Quixote Holohan is also another feature which is on judicial review, or can there be complete absence of an access to judicial review, is a leading case on the point. So I have up till now placed 6 judgments before you. The numbers are rising. The challenges are rising. I have selected those cases which are where the constitutional amendments have been struck down or have been read down, like in Quixote, that there is still a power, the way it was read down in Chandrakumar, that there is still a power under 226. We have had number of amendments to the Constitution. Amendments are challenged on various grounds. The last of the decisions where the amendment to the Constitution was in question was 103rd Amendment, where I had the occasion to be part of the bench. That was in Janhit Abhiyan, or what is normally called EWS reservation. In EWS, there was no question of judicial review, but there was an amendment to the Constitution which was being challenged on the professed ground that this amendment violates the basic feature of the Constitution, that is to say, that in terms of Constitution, only certain sections of people are entitled to be extended affirmative action under the state. So therefore, that's a completely different sphere. What do we get out of this discussion? We get out of this discussion is, if we started from Golaknath, that is to say, any amendment which violates your Part 3 right must be struck down. That was too expansive a sphere which was opened by Golaknath for us. If we allowed that, then every part of fundamental rights chapter, which is Part 3, will be riding at such highest pedestal that it will be impossible for the state to come out with various affirmative actions or compensatory acts or any acts to ameliorate the lots of some of the weaker sections of the society. Therefore, from that highest level, we have now come down to, in terms of Keshwanand Bharati, that very well not all fundamental rights are inviolate. Some of the rights can be deleted as well. As we have right to property, which was deleted from part 3 of the rights. Some of the rights can be amended as well. Some of the rights can be included. Right 21 capital A got included, which was never part of fundamental right of the citizen. So this kind of logic that the parliament must have the power to keep pace with the ethos of the times, to see that the demands of time are also fulfilled. So therefore you give that right to the parliament to make amendments, but at the same time put a filter on that, put a check on that, put some kind of a lid on that. And what you say is, very well, amend you may, but you will not violate basic features of the Constitution. So as I wanted, you are lawyers, some of you are law students, but the idea is to make you aware of what is this concept of basic feature in our Constitution when it comes to judicial review, and how it has been seen, how it has been understood, applied by the Supreme Court in some of the examples or in some of the test cases. So therefore, I gave you these 6 cases. So therefore, that's what I wish to place before you. I have enjoyed this talk as much as perhaps you may have enjoyed listening to it. Thank you so much.
Thank you, sir. Your rich experience in legal profession and justice delivery system, profound knowledge of law, and thorough understanding of society has truly enriched this august gathering. We are truly grateful. I would now request Mr. Harish Adwant to propose the vote of thanks.
Very good evening to the august gathering. Prathama vayasi dattam toyamalpam smarantah shirasi nihita bhara narikela naranam salila amrutakalpam dadyurajivanantam nahi krutamupkaram sadhavo vismaranti. It translates to, a coconut tree takes very little water in its initial years to grow, but never forgets the help and support it receives. The Kalpa Vriksha bears the burden of the fruits throughout its lifespan to bestow upon its people its wondrous offerings, which are comparable to Amruta, the nectar of the gods. In the same manner, noble and righteous persons will never forget the favor and help rendered to them and will continue to serve the mankind throughout their life. Gratitude should not only be a quality, it should be the entire character of a human being. In order to express gratitude at this momentous occasion, I take this daunting task as an opportunity to express my heartfelt gratitude to those who have contributed for making this event a resounding success. On behalf of the Marathwada Legal and General Education Society, the entire fraternity of distinguished luminaries, and everyone present here, I convey my deepest regards and gratitude to Honorable Mr. Justice Uday Lalit Sir for gracing the memorial lecture series instituted in the fond memory of my grandfather, Advocate Vishnupant Adwant, and for sharing with us his invaluable insights on the topic, judicial review as the basic feature of the Constitution. Sir, we are truly humbled by your gracious presence and immensely benefited by your intellectual address. I express my immense gratitude to all the honorable judges of the Bombay High Court, the District Judiciary, and the other members of the judiciary for their valuable presence. I wish to thank the Honorable President Secretary, and all the office bearers of the High Court and District Court Bar Association for their presence. I am extremely grateful to all the senior advocates, Deputy Solicitor General of India, and the colleagues from the legal fraternity for their kind presence. I express my gratitude to the Honorable President, office bearers, and the members of the ML&G Society for the stupendous efforts put in to make this a grand success. I express my earnest gratitude to the respected Vice Chancellors, Principals, and faculty members of all the colleges for their presence. My gratitude extends to the members of the industrial sector and guests from the cross sections of the society. A big thank you to the event management team for support with lights, sound, and photography. I also wish to express my sincere thanks to the print and electronics media for their presence and providing excellent coverage for this event. My special thanks to the teaching and non-teaching staff of the MP Law College for their efforts behind the curtains. I also thank Advocate Neha Kamble for seamlessly anchoring the auspicious event and Mrs. Madhavi Rao for making the documentary film. Last, but definitely not the least, I wish to thank all the students for their presence, as it is for you that the institution relentlessly strives to be better and provide you the best. Thank you.
Thank you, Mr. Adwant. Sri Aurobindo, the great Indian philosopher, had said in his declaration made on 15th August 1947, "Nothing is dearer than the motherland's service. If you will study, study for her sake. Train yourself, body, mind, and soul for her service. Work that she may prosper, suffer that she may rejoice, because that's when the humanity would rejoice." On this note, I declare the event concluded and request you all to please stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंग विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य